In a fixed-date application filed on Tuesday, Attorney General Anil Nandlall was named as the respondent as the Guyana Teachers Union, represented by Attorney Darren Wade, seeks to squash the government's decision to discontinue the deduction of union dues from teachers' salaries monthly and a declaration that the strike is legal. The GTU is also contesting, among other things, the government's decision to deduct monies from the salaries of striking teachers for the days they were absent from the classroom. Hours after the application was filed on Tuesday, Nandlall said he is prepared to defend all the decisions the government has taken with regard to the strike. The GTU is seeking a total of 18 reliefs. The union is alleging breach of their right to freedom and association and assembly, their right to protection from deprivation of property, and their right to be heard before determining that it will cease the practice of performing as an agent of the union to deduct union dues from the wages and salaries of teachers. But the Attorney General on Tuesday outlined 3 general grounds for the application: the decision to cease the deduction of union dues, the decision to deduct the salaries of striking teachers, and the willingness to engage in the continued collective bargaining process. On all 3 grounds, Nandlall says the government's decisions are lawful. He insisted that the government has a right to levy a deduction against workers who are absent from work without permission, leave, or authorization.
Persons are confusing the right to strike with a freedom to strike. The Constitution of Guyana, Article 137, confers upon every worker a freedom to strike, not a right to strike. And there is a huge distinction legally between the 2 concepts. Even a right to strike, like every other right, has responsibilities and conditionalities attached to it. And one of the conditionalities and one of the burdens that the freedom to strike attracts is the right of the employer to deduct wages from the worker who has decided to strike.
The Attorney General claimed that it is the teachers' union that is not engaging by established protocols, but there is more to the teachers' court action. They are also seeking a declaration that the government's claim that the GTU's industrial action is illegal is unfounded and unfair. But Nandlall maintained that the government has dealt reasonably with the union in accordance with good industrial relations and practices and procedures and in compliance with the written terms of engagement that govern the relations between the 2 entities.
We are a working class government. We don't want acrimonious relationships with unions. We want to work with the unions. But we are not going to do so in bad faith. We are not going to do so under duress. We are not going to do so under any form of undue influence. We want to bargain fairly. And that is what the law provides for. And we are not in any way resiling from that legal obligation to bargain collectively with any group of workers in the country. But there must be protocols and established industrial terms of engagement.
Wade, on behalf of the GTU, listed 55 grounds for the application supported by the Judicial Review Act of 2010. He listed a series of exchanges between the GTU and the government dating back to 2020, when the Ministry of Education and the GTU began engagement on a proposed multi-year agreement that demands salary increases and duty-free concessions, among other things. The GTU believes talks have broken down and the process should move to arbitration, but the Education and Labour Ministries maintain that talks are still ongoing.